Hello, we are Group 2A Competition Law and Intellectual Property. This video is to update the progress for subject LB338 Competition Law. Our group research topic is 5G and patent licensing, in which we will be focusing on the 5G FRAND and standard essential patent, EU competition, antitrust law, case study, and suggest recommendations for Thailand to improve. So let's get started. How it is important. Nowadays, 5G is very new to Thailand. Not many people use this internet signal since their devices are 5G unsupportable. So only a few people have an opportunity to use it. However, 5G is important because it is the new virus technology that has the potential to support millions of devices at ultra-fast speeds, and also has the potential to transform people's lives around the world, connecting them faster and better. It improves people quality in many aspects and creates the most convenient experiences for people to connect to each other around the world. Therefore, 5G is really important for us to move forward in the future, and it seems to be used continuously for a long time. So moving to the key research questions, our key research question focuses on 5G and patent licensing. Tanida will be responsible for 5G FRAND and standard essential patent. The objective will be on what is 5G FRAND and SEP, how FRAND and SEP are important to 5G, and its protection scope, then to what extent does it cover. And for the next one, EU competition article, Pishiya will be responsible for this. The main focus of this particular part is the interpretation of Article 101 and Article 102 of TFEU and their legal implications on the case study of the 5G patent, their importance as the forming basis of the EU antitrust policy will also be elaborated.
As for the antitrust law, we will focus on the relevance of antitrust law in relation to 5G and how it is implemented in the case of SEPS and foreign terms. We will also look into the identification of infringement of licensors' contractual FRAND obligations and distinguishing what constitutes an antitrust violation in the case of SEPS. As for the case study, we will look into the case study between Ericsson and Samsung, which are the major mobile companies in the world. And we will also suggest possible recommendations from our perspective for Thailand in regarding to the field of the 5G. Our research approach, we have planned about writing structure, and right now we are in the process of collecting information, and we have decided that we will start writing as soon as we have gathered enough information, and that is our research approach. Main content in our topic, well, first one is the 5G FRAND and standard essential patent, or SEP, their definition and how they are of great importance to 5G. And then we will look next to the EU competition article, which we will interpret on the legal implications of Article 101 and Article 102 of the TFEU, or the Treaty of the Functioning of European Union.
As for the antitrust law, we will be discussing the relevance of antitrust law in relation to 5G and how antitrust law is implemented in the case of SEPs on front terms. So we'll be discussing what constitutes an antitrust violation in the case of SEPs. So how competition law is implemented into the case of SEPs and 5G, and also identifying the infringement of licensors' contractual fund obligations, distinguishing common knowledge between common initial misconception about SCPs on the abuse of dominant position and excessive pricing and anti-competitive discrimination.
The case we will refer to is a case between two big firms in the telecommunication market, which is a Swedish company Ericsson and a South Korean company Samsung. From the upcoming 5G, Ericsson filed a lawsuit against Samsung accusing them of importing and selling products infringing on Ericsson's patent in the US. Both companies have worked together under a contract regarding SEP and cross-licensing agreement. Samsung is required to renew its term. However, as the contract between Ericsson and Samsung came to an end, which spanned a new contract on February 2019, Samsung did not agree with the terms. They rejected the brand compliant offer, which include a compensation payment from Ericsson, and they demand Ericsson to accept the compensation payment in the global cross license. For the analysis part, the standard essential patents, or SEPs, are required by the patent holder as essential to the standardization organization or the European Telecommunications Standard Institute, or the ETSI, which undertake to license this patent to competitor on fair, reasonable, and non-discriminatory terms of run in accordance with the ETSI. But there are still some cons and issues. There is no uniform legal clarity and binding force concerning SEPs and brand conditions from the side of the court. The definition of fair is still not clear that whether it can be expressed to what extent. The person who bears the burden of proof for brand in conformity is not mentioned. The person who is responsible for the brand obligation if an SEP is transferred to another holder is not mentioned. And lastly, the way to calculate the compensation for damages in case of infringement is not stated, in which we will research further whether Thailand is ready for or appropriate to implement these regulations or not. In conclusion, currently we are in the process of researching for more information on our topic, and we will start writing right away. Thank you.